number 24-01336NZ. This hearing is being recorded on Zoom and live streamed on YouTube.
That file was right there. So I do have it. I do have this is and we are on the record, Lisa.
Yes, we are.
Very good. This is the time and date set for hearing on defendant's motion pursuant to MCR 2.116 C8 and C10. I would invite counsel. Will you place your appearance on the record?
Todd Connect, excuse me, Todd Connect, attorney for the defendants.
Very good. And Ms. Ike, would you state and spell your name for the record, please?
Eileen Ike, first name Eileen, last name Ike. I don't know if this is the appropriate moment, like to bring up before we get into it too deeply today that I am worried that the time out soon, and I know that motions for summary disposition hearings are a little bit chewy, and just because I'm worried about that running up against the time I set aside for the hearing today, if it would be inappropriate to motion to adjourn this hearing to another day.
Okay, what do you have coming up, Ms. Ike?
I have to go back to work in 20 minutes.
Okay, well, I've already adjourned this once last time because of, I think, what sounded like a, sort of a health emergency that intervened in this. I'm hesitant to do it again. Let's start it out, at least I'll hear the arguments on it. I'll try to get it done within 20 minutes, and I will acknowledge, right, this was scheduled for 11 a.m., and it's now 11:56 a.m. because my previous motions have taken that long to resolve. So let's get as far as we can with it before you have to go to work. Did you file a brief, Ms. Ike?
I filed a brief in support to my response to the motion for summary disposition.
Okay, you filed a responsive brief here why I should deny the motion, correct?
Yes.
Okay. And was that the same brief that was asking me to grant you the delay, the adjournment last time? Same document, or were they separate documents?
Last time we didn't have an adjournment. As far as I recall, last time what we did was look into whether the defense counsel could have more time for a motion to summary disposition, and that was granted last time. There was no adjournment previously in this case, as far as I remember.
Well, I thought I had a date for a hearing, and I believe I had Mr. Connect here. I may not have had you here on that date, but I adjourned it. I thought it was at your request because there were additional. You got.
I think that was because defense didn't properly serve notice of hearing.
May I address that, Your Honor?
Yeah, go ahead.
I think we adjourned.
Yeah, the case was adjourned. Was scheduled originally in August for our motion for summary disposition. Then it was adjourned until September 10 because the plaintiff didn't show up for the hearing. It was just you and I. And then we had so the court adjourned it till September 10, and then I think the court had a conflict, and then it was from September 10 till October 10. So,
we've had multiple delays along the way to get here, and I do recall, right, one that at least my perception was at request of plaintiff.
Right.
Right.
We've never asked for an adjournment.
Okay. That's incorrect, Your Honor. I was only aware of the August hearing after the fact when we got notice of the September hearing.
Okay. Well, in any case, I did allow it to be heard today. It's Mr. Connect's motion. Mr. Connect, anything to add to your motion?
Well, I won't restate the brief. If I just could make a couple of points to focus the court's attention. And that is that this case has been dragging on. The plaintiff has the counts for defamation, fraud, and statutory conversion, intentional infliction of emotional distress. If even a cursory review of the second amended complaint shows that she has not pled the elements of these claims. And most importantly, her defamation claim is on its face defective because the alleged libelous statement that she claims, which the employer accused her of theft of a time card, was communicated only within the personnel at the law firm who are tasked with HR, with the time cards, with that was their job to do what they did. That she's named like 5 or 6 people in the law firm claiming that they defamed her, but these folks did not communicate anything about her to any third party, first of all, so that there's no publication. And secondly, as you know, there is a qualified privilege under Michigan law in order for her to tag either the law firm or any of these employees. She would have to show malice, and she simply cannot show that because they did their jobs. They basically saw that she had manually filled in her time card to say that she had arrived at 7:30, but they checked the building entrance code and saw that she had actually not arrived until after 8 o'clock. And the problem was that this was not the first time that there had been wrinkles with her time card. And so they looked at that and they said, we're going to terminate you. This is really just a garden variety termination case in which the plaintiff was upset because they accused her of falsifying her time card. Fine, but that's as far as it went. Among these folks who she names in the complaint, importantly, she names each one of them and says what their job is. That on its face shows that they were protected by a qualified privilege. To even under Michigan law, an employer may even defame its own personnel as long as it's not acting maliciously. An employer, it's a policy matter. Employer has the right to talk about its personnel, as did the folks who she is named as defendants here. One of them is her supervisor, another was the office manager, another is the law firm owner, and all of them have a job. So Michigan law protects them, but she can't even get that far because she didn't publish it to any third party. The only evidence that she has that it went outside the law firm was that it was brought up at her unemployment hearing. And as we've cited in our brief, there is an absolute privilege for the employer to make statements in the unemployment proceeding about why the person was terminated. So that can't be the basis for any kind of defamation claim. And furthermore, she got her unemployment ultimately. But so the defamation claim, that's count 1, must fail for numerous reasons. Then she has something called claim for fraud, count 2. That claim is unintelligible. Basically, as I understand it, she's saying that when they spoke to her and said that she had falsely falsified her time card, those statements to her were somehow fraudulent. But the elements of fraud, by clear and convincing evidence, you have to have reliance. You can't defraud yourself. Basically, she's saying that statements to her, she misunderstood, but that's not a fraud claim. I don't know what that is. Then she has a claim for statutory conversion. Again, the elements in her second amended complaint are defective because she did not part with any money. She didn't entrust any money to the employer, which is a critical element of a claim for defamation or for conversion. And then basically she has some sort of wage claim, which if you look back in the files, that court had actually dismissed a claim having to do with her wages earlier in the case when she went to amend her complaint. But it finds itself in this most recent second amended complaint, and it doesn't meet the criteria of conversion. There's no entrusting of the plaintiff's money to the employer, which the employer somehow converted. So that fails on its face. And finally, there's the claim for intentional infliction of emotional distress. And again, a garden variety wrongful termination case in which we've attached the personnel exhibits to our motion. Basically, they had a meeting. They said, we're terminating your employment. And somehow she believes that that's intentional infliction of emotional distress. But as the court knows, there must be outrageous conduct, the kind of conduct that rises to the level of shocking the conscience. And she doesn't even plead that in the, it's like a tack on kind of a, of a claim. And I think it's also important to note, Your Honor, again, this is the second amended complaint, but we had noticed her deposition and she failed to appear for it. And I just want to point that out because the court has been patient and given her wide latitude, given the fact that she's a pro se litigant, and yet, and each time she has amended her complaint, it has become even more ambiguous and does not rise to the level of any kind of a claim. And so for those reasons, I think it's clear that her complaint, and I just want to, the other thing, I guess I said this already, this failure to meet the defamation, any of the elements, there's no publication to any third party. And reason I say that again is because I understand that she's pro se, but if this had been a lawyer, I believe the court would have sanctioned this plaintiff for bringing a case and repeatedly trying to amend, but in each case, trying to not having any met the criteria. And finally, with regard to damages, she has not pled any causation of it as to any damages. It's absent from the complaint. And I tried to figure out what her damages. I came up with $45 maybe. Theoretically, if any of these claims had any merit, which they don't. I don't mean to be flippant, but this is costing the carrier law firm money to have me defend. And I think that it's not just the carrier law firm. She's named, these 5 individuals as defendants, and there's, no one likes to be fired, but when you get fired, you don't turn around and sue everybody at the employer where you worked because they said they gave you a reason why you were fired, and they didn't communicate it out of the law firm to anyone else. And the people who discussed it were all tasked with an aspect of the HR and the records, all of it, and they're all protected by Michigan's qualified privilege, which can only be overcome with a showing of malice, and that kind of malice requires reckless disregard for the truth. I mean, to overcome that qualified privilege, you got to show basically that the employer lied or that they totally disregarded reality. She hasn't even pled anything like that, Your Honor.
All right. Well, let me give Ms. Ike an opportunity to respond.
All right, Honorable Judge Rossi, I'm going to go point by point here. First, I would like to read something to the court. This was sent to me in my email and through no other means on June 9th, 2025 from trconnectlaw@gmail.com. Notice of hearing via Zoom, ID 659-286-4395. Please notice that defendant's motion for summary disposition, etc., will be brought before the Honorable Court on Friday, August 8th, 2025 at 1:30 a.m. or as soon thereafter as counsel may be heard. Now,
It's 1:30 p.m. in reality, not a.m., because I wouldn't hear it at 1:30 a.m. For anyone.
So in my understanding, I thought that was a very awkward plea by defense counsel to the court to let both parties know as soon as the case could be heard, and that we would receive notice from the court about when that hearing would be scheduled. So I would like sanctions against the defense counsel for trying to mislead the plaintiff as to the date and time of a hearing. I had a sticky note in the back of my mind, like maybe I should call the court and ask them if something's going on with that date, but I didn't get to it. And I feel like that's not on me, that I was trying to
Okay, well, it
catch.
sounds like a proper notice of hearing to me. It may have come from Mr. Connect, but that's not at all uncommon, for a party to supply the notice of hearing in its own case to the other party. The court doesn't generate a separate notice of hearing necessarily. We just place it on the docket at the request of the party, and then they're doing the required paperwork. It's the notice. In any case, I've ruled that we're properly here today on the hearing on this. I did grant adjournments. I didn't penalize anyone for not showing up in the past, but I do think we have to hear this today unless there is some compelling reason, why I should delay it even further. So why don't you take the issues in the motion? First of all, he's saying it's not defamation because the information never got outside anyone at the law firm who didn't have some responsibility for managing your employment.
So one of the other points I'm going to bring up is that he claimed the state of Michigan did not approve my unpaid wage and hour complaint, and the state of Michigan did approve that, and I did receive a check from Carrier Law for unpaid wages.
Okay.
Another thing is that for defamation cases for qualified privilege, there are certain elements that allow for qualified privilege to be waived as a defense if those can be proven in a hearing. And
Yeah,
those
that's
elements,
what he's talking about, malice. He
Yeah.
says that there has to be some evidence that not only did they say things that were untrue about you, but they did them with a malicious intent. That is, they said those untrue things in an effort to force you to have a mental breakdown, in an effort to um, provoke some sort of response from you or from others, uh, that's improper. Do you have evidence of any of that?
So one of the qualifiers for malice as a disqualifier for qualified privilege is knowledge of the falsity of these statements, and what I would be doing if
Well, that's just basic defamation, is they know that it's untrue. True enough, but even there, you have to get above that if you're in this qualified immunity world. Even if they are saying an untrue statement, as long as they're not saying it with the intent to wreak some sort of terrible outcome on you, probably not defamation in that context.
qualified privilege is something that requires that someone is not aware of the likelihood that their statement is false, is what I've read into Michigan's definition of the tort, that it does require that for the privilege to remain qualified, someone has to have no cognizance that this statement could be false. And that's where my facts of the case go, is that when you lay them out, it suddenly becomes very odd that all of these people made these choices on this date, considering these other factors, and would have absolutely no idea that this could be very usual, that this could be very in line with something that is not a crime like theft.
Okay, you weren't charged with a crime. They ultimately said there were misrepresentations on the time card, and that's one of the reasons we're terminating your employment. I mean, that's how
Which
I
is
boil this down.
not what my evidence is. My evidence shows that they did say that it was theft.
Do you have that said in as many words by some employee of the law firm?
Yes.
Does that exist? I haven't seen it.
That is in the termination letter, and it is also in recordings that I have of various meetings with employees of Carrier Law.
Okay, and when you're saying they say it's theft, they say it's time card theft?
They said that it was theft.
Okay, just outright theft.
Oh, sorry. They said it was time card theft.
Yeah, okay. I mean, they're characterizing it, within that. And your argument is that would raise to the level of malice, because in the end of the day, theft is a crime. It is, one of the things that can be defamation or slander per se, if you accuse someone else of a crime. But did they do it outside that, circle of people managing you? Did the accusation of time card theft get outside the carrier law firm ever?
I do have the ability to make this argument further, and I would love to make this argument further. I don't have time to do that today
I
at this point.
understand you've got, and I am later than I anticipated on the hearing. All right, well,
Can I
what I'm
respond real
just
quickly,
going to have
Ron?
to do, and I
Very quickly.
apologize to both parties for delaying. The previous motions took longer than I had anticipated. I'm going to have to adjourn this to another available motion date. Lisa, can we give that out right now, or are we going to have to?
I have a couple of dates and times. Our next available is November 14th. Miss Ike, I'm getting a lot of feedback from.
Yeah, me too.
Yep. Someone might have.
There, I just
November 14th
muted
is
her.
fine. Do you want me to renotice that?
11/14, November 14 at 11. Yes, please.
Yeah, that's fine. I'll do a renotice if that's okay, unless you want to do it.
Yep. Does that work for you, Miss Ike, with your schedule as far as you can tell?
Could someone repeat the date and time?
November 14 at 11 a.m.
That works, yes.
All right, we'll schedule it for then.
All right, we'll
I will
schedule it
give
for
it up to 2 hours. We could go to 1 p.m. that day, conceivably right through the lunch hour if needed. And I'll look for the read notice. Thank you, Mr. Connect, and I'll see you both then.
Thank you, Your Honor. Appreciate it.
Thank you.